have counties that must provide bilingual access to Asian language limited English-speaking voters. And within those 10 states, there are about 21 counties that must provide such access. And you would be surprised. These 10 states include Alaska, Alaska, California, Hawaii, Illinois, Michigan, Nevada, New Jersey, New York, Texas, and Washington. So it really is a testament that this provision in federal law for bilingual access to the ballots have endured over these nearly 40 years. Thank you.
Thank you all for staying here towards the end of a long day, albeit an exciting one. And I have to thank Professor Wong for inviting me because, among other things, it allowed me to collect on a 40-year-old bet from J. Stanley Pottinger. So, in my over 40-year career with the U.S. Department of Education Office for Civil Rights, there are two issues that particularly caught fire with me. The first one was Lao, and the second one was disability rights. And I think the reason that Professor Wong invited me here today and put me near the end of this conference is to tell you that Lao is even more important than you already think it is. And I'm going to explain that to you. So I, to some extent, was sort of the Forrest Gump of the Lao case. I helped be on the moot court panel that prepared J. Stanley Pottinger for his argument before the Supreme Court. I saw the argument in the Supreme Court with some disappointment, and I'll explain that later. I heard the decision of the Supreme Court in Lao. And under President Carter, I toured the country with the first Secretary of Education, Shirley Hofstadler, to work on the bilingual education regulations. And it was an incredibly exciting and interesting period of time because what I saw was the rise of the political power of the language minority community. And I think Lao was very critical in that change in authority and power and presence. I negotiated the first big city schools bilingual ed settlement, which was with the city of Chicago. You may not know it, Chicago is a very diverse language community, and it was preparation for my next case, which was Los Angeles, which of course was even bigger. And when I was in Los Angeles, the negotiations took us almost 2 years. And at first, people of color who came to the table, Koreans, Hispanics, Latinos, Chinese, they were lower level administrators in the LA school district. By the time our negotiations were over, at least 2 of them had run for the school board, and all 4 of them had much higher positions than they had before. And I think it's very important to understand that Lao was, in many communities, the vehicle by which language minority populations came to power in cities and particularly in school districts. So, and I think, Henry, I think you filed the complaint. I did the first bilingual ed case against Kaiser Hospitals, and I think that was also a significant case. And just to quickly tell the story, I'm sure Henry knows the details better. The Chinese Restaurant Workers Union paid millions of dollars to Kaiser for medical coverage for their members because the services were at that time all monolingual English services. They rarely used the services they were paying for, which of course Kaiser liked very much, right? What's better than people who pay in and then don't use their services? But I think it's fair to say Kaiser takes a much different attitude towards language these days. I notice I'm the only Anglo client on the all Chinese ward in Oakland. So what the heck does this have to do with disability law, which is the other issue that caught fire with me. And I'm going to take you into this issue because I want you to understand globally what the impact of Lao has been. So I'm sorry for sounding like a law school professor, but we're going to need to go through a little legal history just for a second. So the first time that inequality or discrimination is defined in American law is in the Emancipation Proclamation. Essentially, the principle is people can't be property. And I think that's a very self-evident proposition, at least to us today. It doesn't twist, you don't have to twist anybody's arms to realize people can't be property. The second stage was that segregation, even separate but equal, is inherently discriminatory. And I think people get that, but maybe what they don't understand because they haven't lived long enough to have been in segregated states, I was, when I was desegregating schools, is that the purpose of segregation is to give people a sense of inferiority, to constantly stigmatize them, to constantly remind them, you're not as good, you're not as capable, you're not as able, you're not as much a human being as other people. Nonetheless, I would say today everybody understands what's wrong with segregation. And then we get to what we call in the law disparate treatment. And disparate treatment essentially posits similarly situated people ought to be treated the same, or another way to say that is identical treatment is equal treatment. So let's say you have a law firm, and the law firm has a rule, no clerical may take more than 60 minutes for lunch. But all the white clericals generally take 75 minutes for lunch. And an African American woman takes 75 minutes for lunch and she's fired. That's discriminatory, right? And no court would stand for that. And I think that far in the law, everybody gets. Everybody understands that. And that's what the San Francisco Unified School District understood. Identical treatment is inherently equal treatment. So along comes the Civil Rights Act of 1964, and along comes a case called Briggs v. Duke Power. So Duke Power is a big power producer in Georgia and North Carolina. And like all southern industrial units, the way Duke Power was organized was you had a white line of seniority and a black line of seniority. And the black line of seniority jobs probably paid at the top just a little bit more than the bottom of the white line of seniority. Along comes the Civil Rights Act of 1964. This is no longer lawful. So Duke Power has to decide, what are we going to do for those technical, important, serious jobs at the top of our white line of seniority, like running a steam generator, which, by the way, if you run it wrong, you can kill a couple hundred people in an afternoon. So they say, okay, we're going to be objective and neutral and non-discriminatory, and we're only going to give this job to people who hold a high school diploma and get a score of 21 or higher on the Otis Quick Intelligence Test. And in fairness to Duke Power, if you were an African American man with those qualifications, you could get hired. And if you were a white man without those qualifications, you could not get hired. Identical treatment? Equal treatment? No. No. Why? Because the chance of a white man having a high school diploma in those two states was 4 times as great as that of an African American man, and the chance of a white man getting a 21 or higher on the Otis Quick Intelligence Test was 7 times greater than an African American man. Well, so what's the problem? So the problem is, if those criteria are valid predictors of who will safely and effectively run the steam generator, great. But if not, they're what the Supreme Court called in the majority opinion an unnecessary headwind, right? It looks on its face like it's non-discriminatory, but in reality it is. And you can use this if it validly predicts who will be successful, but if not, it's just the appearance of equality. It's not true equality, right? Can you see how maybe we're marching a little beyond identical treatment is equal treatment? And then along comes Lau v. Nichols. And what was the heart of San Francisco's defense? Their defense was, we spend the same amount of money on every child, they get the same books, they get the same curriculum, their teachers are just as experienced, their classrooms are just as warm, they're just as freshly painted. How could we be discriminatory? And what the U.S. Department of Education Office for Civil Rights said, not everybody comes to the starting line with the same experiences. And if the experiences are fundamentally different enough, and if they are related to race, sex, or national origin, in this case national origin, it can be discriminatory to ignore those differences. Now, why was I disappointed in the Lau decision? Because the Supreme Court of the United States did not say it violates the 14th Amendment of the United States Constitution. They were ambiguous, but in my opinion, didn't even clearly say it violates Title VI. What they said was, U.S. Department of Education Office for Civil Rights, if you want to use your authority to interpret Title VI, you may use your authority to interpret it in this manner. So to a great extent, this was deference to the authority of the United States government to interpret its laws, and to conclude that identical treatment was not necessarily equal treatment. Can you see how the arc of law, as Martin Luther King would say, you know, the moral arc of the universe is very long, but it bends towards justice, right? And we're bending towards justice. So what the heck does that have to do with disability rights? So shortly after the Lau decision came down, a group of young troublemakers in Washington have been given the duty to write the regulations implementing Section 504 of the Rehabilitation Act of 1963, a 35-word law that just says, if you receive money from the Department of Education, you can't discriminate on the basis of disability. That's it. That's all it says. So I think that law would have addressed non-identical treatment. In other words, if you said, no blind student can enroll in this college, the law would have addressed that. But there's not one single word about reasonable accommodation. And as I asked my disability law